Can you adjust status with inadmissibility waivers? Imagine being in the United States and wanting to become a lawful permanent resident, but facing a barrier called inadmissibility. Many people wonder if they can still get their green card despite this obstacle. The answer is yes, but it depends on certain factors. Adjustment of status allows someone already in the country to apply for a green card without leaving. However, if you have grounds of inadmissibility, you might need a special waiver to move forward. Inadmissibility means you do not meet all the legal requirements to stay or enter the U.S. legally. This can be because of past criminal convictions, immigration violations, health issues, or misrepresentations on your application. If you are inadmissible, you cannot simply file for adjustment of status and get approved automatically. You need to ask for a waiver, which is a formal request asking the government to forgive your inadmissibility. To apply for a waiver, you use Form I-601, which is the application for waiver of grounds of inadmissibility. Along with this form, you submit evidence showing why you deserve the waiver. Common reasons include demonstrating that your absence or denial would cause extreme hardship to a U.S. citizen or lawful permanent resident family member. For example, if your spouse or child would face serious hardship without you, that can strengthen your case. Not all grounds of inadmissibility can be waived. The eligibility depends on the specific reason you are inadmissible and the type of visa or adjustment you are seeking. Some waivers are more straightforward, while others are more complex and requiring detailed evidence. For instance, if your inadmissibility is due to a criminal conviction, you might need to show rehabilitation or that the crime does not disqualify you under certain conditions. When applying to adjust status, you include the waiver request with your application. You must gather documents like proof of family relationships, medical records if health is an issue, and detailed hardship statements. The process is discretionary, meaning even if you qualify, approval is not guaranteed. The decision depends on the strength of your case and the evidence you provide. Certain categories have special rules. For example, applicants under the Violence Against Women Act, asylees, or those with temporary protected status may have different waiver options or eligibility criteria. These categories often have protections or exceptions that can help overcome inadmissibility issues. For Latino families navigating the U.S. immigration system, understanding that inadmissibility waivers exist can be a game changer. Many families face complicated histories or past mistakes, but waivers can open a pathway to stay together. It's important to work with an immigration attorney or accredited representative who can help prepare a strong waiver application. Gathering detailed evidence about your family ties and hardships is key. Remember, the waiver process is not automatic. It requires careful preparation and patience. Keep records of all immigration documents, entries, and past proceedings, as these will support your case. In the end, adjusting status with inadmissibility waivers is possible, but it requires meeting specific legal standards and submitting a well-documented request. For many Latino families, this process offers a real chance to stay united and build a future in the United States.